Welcome back to the Legal Alternative Podcast with me, Sam Pawson, joined as ever by Nils. Nils, how are you?
I'm very good, Sam. How are you?
I'm good. Fresh off seminar duty.
Looking
Not
smart.
not that I normally don't dress up for you, Nils, but it's in the suit and tie today. We were just talking off air, back to Huddersfield. So I haven't done a seminar in our Huddersfield office for a while. We thought probably pre-COVID, so quite a long time, and it was really good to be back in Huddersfield with the seminars. We did flexible working today, so went very well. Lots of questions, lots of interaction. So really good one. So yeah, we're slightly delayed in recording the podcast than our normal one together, but no, good to catch up pre-Easter for us, which I think on the pod. How's things with you?
Very good. We've had some really interesting cases this week. Can't quite speak about them yet because they're still ongoing, but looking in the coming months to letting the listeners know about some really interesting work that we've been doing.
Fabulous. I think I'm kicking us off first today. Quick update on a case again. Had some press. What I want to talk to you about this is it's an Equality Act case, but it's actually for a job applicant. So we've talked previously a lot about obviously reasonable adjustments, discrimination for employees. I think it's important for the kind of listeners to know that actually the Equality Act also applies to prospective employees. So the net is a lot wider than in kind of Employment Rights Act claims. So I thought really good case example. It's a bit of a headline grabber as they always are, but actually there's some useful learnings generally about application processes, what your selection criteria is. So case involves a claimant, Miss Veziai, and Royal Marsden NHS Foundation. Apologies for my butchering of the pronunciation. Headline grabbing article is that they've been awarded 7K after anxiety impacted an interview. So this is for a case for an unsuccessful applicant. So I'll go through the case quite quickly. So claimant interviewed for a job in the pathology department at the Royal Marsden NHS Foundation. Although she was considered appointable, she was not selected because another candidate was deemed to have answered questions more directly and succinctly. After the interview process, the claimant evidence explained that the interview started late, and as in the company started, she was on time, but they started late, which impacted her anxiety, her clarity, and her ability to communicate. In the factual circumstances, the successful candidate then decided to withdraw from the role, and the company determined not to offer the role to the claimant, despite their previous acknowledgement that she was appointable. The tribunal therefore ruled that decision placed her at a disadvantage in light of a disability being her anxiety condition, and that they have failed to make a reasonable adjustment to their process in light of that anxiety that the claimant suffered. So again, bit of a headline grabber that I'll unpick slightly. I think the critical thing I want to kind of make clear first is we are dealing with the NHS Foundation, whose recruitment processes themselves are very different to a lot of our listeners. So having candidates that are appointable is probably a bit of an alien term to lots of organisations in the private sector, where it's going to be a case of the best client gets the role. There is a bit more as part of that internal process where there is determinations made almost before the application is made, especially if you're dealing with internal candidates, where often in civil service or in the NHS, roles are much more, there's obviously set criteria, set standards, set expectations, and there is a degree of do you meet them? If you do, you need to be considered for the role rather than the private sector. Lots of learnings, again, I think from here, that irrespective of that someone is just merely an applicant to a role, that they are protected from the Equality Act. And obviously that requires you to make reasonable adjustments. I think a lot of companies will be aware that, when that, if that's a physical premises, making adjustment to the interview process, I think a lot of listeners are probably comfortable with that. The fact that this goes further and actually your criteria for selecting or how someone performs in the interview also needs to be taken into account, and that can be an acceptable adjustment if someone doesn't perform as well because they have, for example, in this case, obviously an anxiety-based condition. I know that isn't comfortable for a lot of companies and a lot of organizations who say, if they perform badly in an interview, why do I need to recruit them? It's about taking that adjustment. A case that important to flag, it is very fact dependent and, as I say, very sector dependent. So please don't take this as me, Sam, saying I must hire people who perform badly in an interview. It's not. Quite specific circumstances linked to the fact that she was appointable, but nevertheless, I think an important case to flag. Don't know, any observations, Nils, from you?
Presumably the adjustment that should have taken place is that the scoring, so she was scored that she didn't answer questions as directly as the other candidate.
Yeah.
Presumably the adjustment would have been, we will score in light of the fact that it's someone who maybe didn't answer those questions directly, but bearing in mind the disability.
Exactly. Yeah. So they didn't really consider her score in light of her disclosures about her anxiety. And I think it's not helped that the preferential candidate was seen to answer them directly and succinctly. So you're not treating them. You're actually using something that the claimant would struggle to do because of her condition. And critically, the fact that the interview started late. So could they have adjourned it? Could they re-interview or things like that? I think would be, the adjustments. And obviously the failure here is to not consider her again once that the successful applicant withdrew from the process. Yeah, things to take out. Useful, broad case, but as always, very fact specific.
On the late point, I assume the best thing to do would have been to just say we started late, but you're still going to get the full allocated time.
Do you need some time? So I think the evidence of cases that made her feel rushed and frazzled. So perhaps it would have been best to, as you say, just to reassure that you've got exactly the same amount of time, or to ask if she needed to re-adjourn the matter, because people get het up, and there's nothing worse than thinking you're late for an interview or you've got the wrong times. Yeah, those kinds of learnings from it. It's hard, especially when you're interviewing people back to back to back to back. Interviews do overrun sometimes if you've got if there's obviously the candidate before gets talking. So again, understandable means, and it's why it's got some attention as a case, because I think a lot of people go, they were unsuccessful. Why has this person got 7K? It's not our fault. We were late, etc., etc., etc. Yeah, as always, it's quite harsh lessons to learn.
Yeah, no, absolutely.
Fabulous. On to you.
Some people might say not for the first time. I'm going to be talking rubbish today. So something I hear often. All this time, I'm actually talking rubbish.
Rubbish.
It's only a little update, but I think it's quite an interesting one because I've seen on the news quite a bit these absolutely monster fly tipping sites. In my head, very naively, fly tipping is, when you drive past a tatty old mattress, some black bin bags dumped at the side of a local beauty spot, which is obviously awful. But on the news, I have seen some absolutely enormous, almost unbelievable sites of fly tipping on an industrial scale, organised crime. Something I never thought about really until I saw those news articles. And the government and the department in question is the Department for Environmental, Food and Rural Affairs, which is DEFRA, who we've no doubt all heard of. They've actually announced that they're going to be expanding the powers of the Environment Agency to deal with this. So it was announced just a couple of days ago, 15th of March, that there's going to be what's called a new zero tolerance approach to waste crime, which I think is fairly uncontroversial. Expanding the Environment Agency's powers under Police and Criminal Evidence Act, the Proceeds of Crime Act, and other related legislation. So what the government's actually done is published its new Waste Crime Action Plan, set out a tough approach to waste crime from fly tipping to large illegal waste sites. It's going to allow Environment Agency officers to intervene earlier, bring more waste criminals to justice, and disrupt the finances of the organised gangs behind illegal waste. It strikes me that some of these powers are actually similar to what you hear in the immigration debate. smash Mr. Big at the top, and it will hopefully trickle down to make these sites less prevalent. So the reforms will make the Environment Agency one of the few regulators with these significant powers. It says the government is exploring how enforcement bodies can share information with banks and finance companies to inform them of waste criminality. So again, giving powers hopefully to the Environment Agency, which would enable them to access information, to make it easier to smash these criminal gangs. So not a hugely high profile legal update. Just a couple of things from me. I don't do a lot of work. In fact, don't do any work against the Environment Agency. I'm quite surprised the Environment Agency can already have these powers. Hopefully it's a good thing these powers come into play and these very, very nasty sites hopefully get shut down because of that. Second of all is, will these be narrow, which I would be interested to see, narrow just to these, or are they going to be more general in relation to the Environment Agency? So not only using these powers to tackle these particular crimes, the wider ambit that the Environment Agency faces. Yeah, I thought it was quite an interesting.
Now, tell me if my inference is correct. You might not know. Is the inference that they know who is doing this wide-scale waste sites in terms of the criminal activity, but and there is a feeling there is no powers to, therefore the powers are too limited to bring them to justice, and therefore this is why giving the regulator these powers will make a difference, rather than we've got no idea who it is and we might therefore need to investigate. I'm guessing if they feel that there is a lack of enforceability, that there's an acknowledgement we know who it is, we just don't have any powers to deal with it.
The answer is I don't know, but there must be a problem, which is why the Environment Agency's powers are being expanded. It might be that they don't know. It might be that these are, I suspect, in a similar way to gangs that deal in illegal immigration, gangs that deal in, these people are clever. And the people that enforce these areas of law do need appropriate powers to be able to go and look at finance records and that sort of thing, to tie it all together. And it sounds like at the moment the Environment Agency don't have those. And by giving them, hopefully it can crack these crimes at source. Because the sites I've seen on television are they're scary. There was one of the sites where most of it just went on and on and on. It was huge. So yeah, I just thought it was quite an interesting.
Absolutely. As you say, again, not that I don't think anything in these days is uncontroversial, but one even in our sphere would seem relatively uncontroversial as a positive thing.
Yeah, absolutely.
Fantastic. As I say, a bit of a podcast update, I think, if anything. I think, Nils, it's our last time together for a few weeks. Both have an Easter holiday. There will be a podcast out next week that we are going to probably, without you, Nils, do a bit of employment focus. And then we will have a bit of a 2-week break for Easter. Few things coming up, lots still going on. I would, in terms of my field, relevant event coming up in April. We're doing a seminar on the Employment Rights Update and the Employment Rights Act coming in April. Details in the description and on the website. So lots still going on, and lots for us both to catch up on.
Absolutely, yeah. Looking forward to doing the pod probably in a month's time. I think we were saying yesterday, wasn't it?
Yeah. So we'll be back then, hopefully in person. But and until then, it's goodbye from me.
Goodbye from me. Have a good Easter.
Thank you. Welcome back to the Legal Alternative Podcast with me, Sam Pawson. Joined as ever by Nils. Nils, how are you?
I'm very good, Sam. How are you?
I'm good. Fresh off seminar duty.
Looking smart.
Not that I normally don't dress up for you, Nils, but yeah, in the suit and tie today. We were just talking off air, back to Huddersfield. So I haven't done a seminar in our Huddersfield office for a while. We thought probably pre-COVID. So quite a long time, and it was really good to be back in Huddersfield with the seminars. We did flexible working today, so went very well. Lots of questions, lots of interaction. So really good one. So yeah, we're slightly delayed in recording the podcast than our normal one together, but no, good to catch up pre-Easter for us, which I think on the pod. How's things with you?
Very good. We've had some really interesting cases this week. Can't quite speak about them yet because they're still ongoing, but